Breaking alert! The new U.S. immigration law officially came into effect today, sending shockwaves through the entire U.S. immigrant community. Countless green card holders are closely monitoring this development and seeking details. If you hold a U.S. green card, or if you have relatives or friends who do, the information I am about to share could directly impact your ability to maintain your status, plan international travel, or advance your naturalization process. This is not an unverified rumor or a draft bill still under congressional debate. It is a formally enacted law with immediate legal effect. Its implementation timeline is far more urgent than most green card holders anticipated, leaving no room for delay. I urge you to watch this video until the very end to fully grasp the core points and critical changes of this new immigration law. Only by doing so can you securely maintain your green card status. Avoid the hidden traps that could jeopardize your immigration status and prevent yourself from falling into pitfalls due to a lack of knowledge. If this is your first time watching my videos, let me briefly introduce myself. This channel is dedicated to sharing updates on U.S. immigration trends and delivering strictly verified, practical immigration information. Reliable, no fluff, just solid content. Before we dive into the specifics of this new immigration law, let's clarify some foundational knowledge. The green card, as it is commonly referred to, is formally known as the permanent resident card. Holding this card grants you the right to reside and work legally in the U.S. long term, making it one of the most valuable immigration statuses globally, one that countless individuals strive for over many years. However, many green card holders overlook a crucial detail. Having a green card is not just about enjoying U.S. rights. It also involves ongoing legal obligations. With the passage and implementation of this new immigration law, these obligations have fundamentally shifted, becoming stricter and more specific. It is important to understand that U.S. immigration law is not a static, fixed rule or a paper clause gathering dust on a shelf. Core federal agencies such as USA Citizenship and Immigration Services, USCIS, and the Department of Homeland Security, DHS, along with laws enacted by Congress and executive orders issued by the government, regularly update, adjust, and refine immigration policies in response to changing national circumstances. While past adjustments often involved minor refinements with negligible impact on green card holders, the new immigration law represents the most significant overhaul in over a decade. Millions of U.S. green card holders must pay immediate attention. There is no room for complacency. Why has this new immigration law, which is set to take effect in January 2026, caused such widespread concern and anxiety within the immigrant community? The main reasons can be summarized in 3 points. Firstly, it fundamentally overhauls decades-old immigration compliance requirements, rendering many previously acceptable practices potentially non-compliant. Secondly, it introduces a new, comprehensive verification process that will directly affect green card holders' ability to travel internationally and enter the United States smoothly. Thirdly, it has unexpected consequences for those preparing naturalization applications, significantly raising the difficulty and scrutiny standards for citizenship. From a broader immigration policy perspective, U.S. immigration policy in 2026 can be summarized by 3 keywords: modernization, strict enforcement, and strong oversight, coupled with policymakers' repeated emphasis on status integrity. This new immigration law is a crucial step in the transition of the U.S. immigration system towards this core orientation, representing a significant measure to advance the standardization and digitization of immigration management. Now, let's cut to the chase. No beating around the bush, no tricks. I will break down the 4 core impacts of the 2026 Legal Permanent Residency Integrity and Verification Act for you one by one. Although the original text is lengthy and obscure, riddled with legal jargon that is difficult for the average person to understand, I will summarize each key point in plain, straightforward language. That is clear, thorough, and easy for every green card holder to understand, remember, and apply. The first core change directly affects every green card holder's ability to maintain their status, specifically the requirements for retaining green card eligibility. The new immigration law explicitly states that all U.S. green card holders must verify their permanent resident status every 24 months, using an official database designated by the federal government. This is an entirely new legal obligation, a requirement that has never existed before. Previously, green card holders' obligations were relatively straightforward. Updating their residential address was USCIS after moving essentially fulfilled their core duty. Additional documentation or procedures were only required when traveling abroad or applying for naturalization. Going forward, every green card holder will receive an official identity verification notice from USCIS. This notice will be sent either as a paper letter to your registered residential address or as an email to your designated email account. The notice will require you to confirm a series of basic details, including your current residential address, employment status, and any intention or action to relinquish your U.S. permanent residency. The online verification process is straightforward. By following the system prompts step by step, it can be completed in about 15 minutes. However, it is important to note that failing to complete the verification process within 60 days will automatically trigger a review, your identity by USCIS. This will necessitate preparing additional materials and navigating more complex procedures, which could affect the stability of your green card status. Consider the following example for clarity. Maria obtained her U.S. green card in 2022. Under the previous regulations, provided she resided legally in the U.S. and avoided criminal activity, her green card remained secure without the need for periodic verification. However, under the new immigration law, she will receive a status verification notice from USCIS every 24 months, beginning in 2027. She must log into the new USCIS system in time to verify her information and submit the application. This is a mandatory obligation for all green card holders. Failure to do so on time may result in identity verification issues or even green card revocation. A second key change directly addresses the most pressing concern for many green card holders: the regulations governing international travel and re-entry. The new immigration law explicitly states that any green card holder who stays outside the U.S. for more than 180 days on a single trip, or who accumulates over 180 days abroad within a 12-month period, will face enhanced scrutiny from customs upon re-entry. This means that entry will no longer be as straightforward as before. First, however, let me reassure you, there's no need for excessive panic. Facing enhanced scrutiny does not necessarily mean that you will be denied entry. You simply need to prepare sufficient, compelling evidence in advance to demonstrate to customs that you haven't abandoned your permanent residency rights in the U.S., and that you still consider the U.S. your primary place of residence. So, what exactly is enhanced scrutiny? Put simply, it involves a secondary examination by customs focusing on the strength of your ties to the United States. Key factors include whether you have stable employment, own property, or hold a long-term lease agreement in the U.S., whether you have immediate family members residing there, and whether you have paid your U.S. taxes on time. This secondary inspection process takes significantly longer than standard entry screening. If you are planning to enter the U.S. after a long trip abroad, make sure you allow enough time to avoid disrupting your subsequent itinerary. Prior to the introduction of this new immigration law, an unwritten industry practice existed. Green card holders who had been abroad for over 6 months might face brief questioning by customs upon re-entry, but only those absent for over a year risked being deemed to have abandoned permanent residency. Now, however, this new immigration law explicitly sets the threshold for stricter scrutiny at just 6 months. This effectively turns the former unwritten rule into an overt legal provision, imposing tighter requirements on green card holders. They can no longer exit the country and stay abroad for extended periods as before. Let's look at a real-world example to better understand this regulation. Software engineer Raj holds a U.S. green card. His company has assigned him to work at its Indian subsidiary for 7 months, meaning that a single departure would exceed 180 days. Under the old system, Raj might have faced only a few work-related questions from customs upon returning to the U.S., typically entering without significant obstacles. However, under the new immigration law, he must now prepare a complete set of supporting documents in advance. These include a long-term U.S. lease agreement or proof of property ownership, his employment contract with a U.S. company, U.S. tax returns from recent years, and documentation proving family ties within the United States. The purpose of providing these documents is to demonstrate to customs that Raj is temporarily working abroad, has not abandoned his permanent residency rights in the U.S., and intends to return to live and work in the country. If Raji knows in advance that his absence will exceed 180 days, he must also submit a notification form to USCIS before departure. In order to fulfill his reporting obligation, failure to do so may result in additional scrutiny upon entry. A third major change introduces an annual reporting obligation for certain categories of green card holders. Many may wonder who exactly must fulfill this annual reporting obligation. It primarily applies to 3 categories of individuals. You can check your own situation against these categories. The first category includes individuals who obtained U.S. green cards through employer sponsorship. The second category comprises individuals who acquired U.S. green cards through investment immigration programs, such as the well-known EB-5 Investment Immigration Program. The third category consists of individuals with conditional permanent resident status, most of whom obtained temporary green cards through marriage-based immigration. If you fall into one of these categories, you must submit an annual report to USCIS each year. The purpose of this report is primarily to confirm your current employment status, i.e., whether you are still legally employed in the U.S., and remain an employee of your sponsoring employer, and, for investment immigrants, the status of your business activities. For individuals who obtained conditional permanent residency through marriage, the annual report must also confirm the legitimacy of the marital relationship and the absence of fraudulent marriage circumstances. Please note that this annual report is entirely distinct from the annual tax filings we all complete and cannot be used as a substitute for them. Furthermore, this is not the same process as the biannual status verification mentioned earlier. The reporting deadlines, content, and purposes differ significantly. It is crucial to distinguish clearly between these 2 obligations. Avoid confusion and ensure that neither is neglected. U.S. Lawmakers explain that the core purpose of establishing this annual reporting obligation is to prevent immigration fraud and combat false immigration applications effectively. This ensures that individuals who obtain green cards through specific pathways, such as employer sponsorship, investment immigration, or marriage-based immigration, actually reside, work, or engage in related activities in the United States, as promised in their applications, without abusing U.S. immigration benefits, or fraudulently obtaining green card status through false documentation. The fourth key change directly impacts all green card holders who are currently applying for naturalization or who are planning to apply for U.S. citizenship in the future, a development that many long-standing immigration attorneys did not anticipate, highlighting the suddenness and broad scope of this reform. The new immigration law significantly extends the period of continuous residence reviewed during naturalization applications. Previously, USCIS only needed to verify the applicant's resident status for the 5 years preceding the naturalization application to confirm compliance with the continuous residence requirement. However, under the new law, USCIS now has the authority to retroactively review an applicant's entire permanent residency history, including all residency, travel, and compliance records, to assess whether the applicant has genuinely resided in the United States and meets the core requirements for naturalization. The practical impact of this change can be illustrated by the following example. Suppose you have held a U.S. green card for 8 years and are now preparing to file your naturalization application. Under the previous rules, USCIS would only review your resident status for the most recent 5 years to determine whether you had met the continuous residence requirement and had taken any prolonged absences. However, under the new immigration law, USCIS can now examine all relevant records from your entire 8-year period. They will meticulously review whether you had any absences exceeding 180 days during those 8 years, whether you violated any immigration regulations, whether you fulfilled all your obligations as a green card holder, and whether any other circumstances disqualify you from naturalization. While the required 5 or 3-year continuous residence period for naturalization remains unchanged, the scrutiny and rigor of the naturalization review process has increased significantly. For applicants with complex travel histories, frequent outbound trips, or extended periods abroad, consequently, the threshold for successful naturalization has risen. Many green card holders have recently been discussing this new immigration law, with many expressing shock and anxiety. In reality, these feelings do not stem from the law directly revoking anyone's green card status, but rather from 3 core reasons. First, the lack of widespread advance notice and publicity. Although this bill had previously been debated in Congress, it was never widely publicized. It wasn't until the week it was formally passed and took effect that the mainstream media began to cover it. Many green card holders only learned of these major changes after the law came into effect, leaving them with no meaningful time to prepare or adjust. Secondly, there is the inclusion of retroactive review provisions. Green card holders who traveled abroad frequently and stayed long-term years ago, believing they had fully complied with the old rules, may now face immigration officers scrutinizing their exit records from 5, 6, or 7 years ago during naturalization interviews. Past unresolved issues could resurface, potentially impacting the outcome of their citizenship applications. Thirdly, the newly imposed administrative burdens are overwhelming. The requirement for status verification every 24 months, annual reporting for specific groups, and a significantly increased documentation needed for travel all demand a great deal of time and effort from green card holders in terms of organization, filing, and follow-up. These new responsibilities and burdens considerably impact their daily lives and work. At this point, I must address several common concerns circulating online. Stay vigilant and don't be misled by false information. Let's address these concerns with facts and legal provisions to dispel unnecessary anxiety. The first common fear is that your green card will be confiscated by customs the moment you leave the country. This is absolutely false. Green card holders can still freely enter and exit the United States and engage in normal international travel. The new immigration law does not prohibit green card holders from leaving the country. It merely requires individuals to prepare relevant supporting documents before departure and to keep track of the time they spend abroad. In order to avoid exceeding 180 days per trip, or cumulatively. As long as these requirements are met, smooth departure and re-entry are guaranteed, and there is no risk of green card confiscation. The second common fear is that missing the identity verification deadline will result in immediate deportation, which is another common misunderstanding of the new immigration law. In reality, failing to complete identity verification on time does not result in immediate deportation. Instead, it initiates an immigration review process. During this review, the USCIS will send multiple reminders, providing ample opportunity to complete the identity verification and related procedures. However, if you ignore these official notices completely, refuse to fulfill your identity verification obligations, and fail to respond at all, this could make your green card status extremely complicated. Subsequent handling would become extremely difficult, and you might even face the risk of your green card becoming invalid. But you absolutely will not be deported immediately. A third common cause of panic is the belief that this new immigration law specifically targets individuals of certain nationalities or ethnicities, such as Chinese green card holders. This is an erroneous interpretation and does not align with reality. The new immigration law applies to all U.S. green card holders, regardless of their country of origin or ethnicity. It treats everyone equally under the same provisions and standards. No specific nationality or ethnicity is targeted. There is no need for overinterpretation or undue anxiety. Here's a summary of the key points to help you avoid panic. This new immigration law is not designed to make things difficult for anyone. Its main purpose is to strengthen the responsibilities of green card holders, improve identity verification and oversight, and standardize document preparation requirements. Provided you maintain genuine ties to the United States, fulfill your obligations on time, and comply with immigration regulations, your status is not at immediate risk. However, ignoring the new rules and hoping for the best could land you in trouble. Ignorance is the greatest risk. Since this new immigration law came into effect today, immigration law firms across the U.S. have been inundated with work. Many immigration attorneys are working overtime to study the bill's specific provisions and develop response plans for their clients. Sarah Mitchell, a managing attorney at a prominent New York immigration law firm, stated in a media interview that this new immigration law is the most significant and comprehensive overhaul of green card holder obligations in 15 years and will impact millions of green card holders. Her core advice to all green card holders is to maintain complete and organized records of all immigration-related documents, including proof of residence, employment verification, tax records, and travel history. Simultaneously, clearly maintain all ties to the United States and avoid extended absences abroad. Never assume that previous rules still apply, and never take chances. Stay informed about new regulations, adapt to new requirements, and avoid making mistakes due to carelessness. Regarding this new immigration law, U.S. policy analysts have offered differing perspectives and interpretations. Experts from the Migration Policy Institute note that the enactment of this legislation reflects a significant trend in current U.S. immigration policy, a gradual shift towards digital verification systems for immigration management, coupled with intensified oversight of immigrant status to enhance efficiency and standardization. The Institute also noted that countries such as Canada, Australia, and several European nations have long implemented similar immigration identity management measures, requiring permanent residents to periodically verify their identity and report relevant status updates. The reform, therefore, aligns with this global trend in immigration administration. However, some U.S. immigrant rights organizations have raised concerns about the new law. They are worried that elderly green card holders with limited English proficiency, as well as those living in rural areas without internet access or technical support, may find it difficult to meet these new requirements and successfully complete the identity verification and annual reporting procedures. Consequently, these advocacy groups have appealed to the U.S. government to provide comprehensive outreach services and support measures. These include multilingual guidance services and offline assistance channels to help vulnerable populations navigate compliance requirements and prevent potential immigration risks due to objective limitations. Next, let's focus on the U.S. government's official response to one of the most critical concerns. This afternoon, the U.S. Department of Homeland Security formally released an implementation statement regarding the new law. The statement explicitly states that the biometric verification system for green card holders, which is required every 24 months, will be introduced in phases over the next 6 months. It will not be implemented all at once, allowing sufficient time for adjustment and preparation. Additionally, the DHS has made several commitments, launching a multilingual verification portal to accommodate green card holders with different native languages, providing dedicated telephone assistance services for individuals without internet access who cannot complete online verification, to help them fulfill their verification obligations. Clear, concise, and easy-to-understand operational guidelines detailing the verification process, key timelines, and important considerations will be mailed to every registered green card holder. Notably, the first wave of verification includes a 90-day grace period. Those who complete verification within this period will not be considered non-compliant. This humane arrangement is designed to help everyone adapt to the new regulations. USCIS has also announced the launch of a dedicated webpage and hotline for inquiries about the new immigration law. These resources will address green card holders' questions about the new requirements specifically, including the identity verification process, annual reporting obligations, and changes to naturalization reviews. In the announcement, USCIS emphasized that the core objective of introducing these new regulations is to promote lawful compliance among all green card holders and standardized immigration management procedures, rather than to penalize any individual green card holder. As long as individuals approach these new requirements in good faith, actively cooperate, strive to comply, and promptly seek guidance and resolve issues as they arise, the USCIS will provide the necessary assistance and support to help everyone complete the compliance procedures smoothly. Scholars in the field of immigration law have also offered professional insights into this new immigration law. They remind all green card holders of a crucial distinction. This new law does not alter the fundamental nature of U.S. permanent residency, nor does it deprive green card holders of their core rights. In other words, you remain a permanent resident of the United States, with a right to long-term residence, legal employment, and access to relevant social benefits. These core entitlements remain unchanged. What has changed are the administrative frameworks and procedural requirements surrounding maintaining and proving permanent resident status, which have become stricter and more standardized. There is no need to be overly concerned about your core rights being affected, as long as you comply with the law. Currently, a broad consensus has emerged across U.S. society regarding this new immigration law. For green card holders, the most critical task is not to panic or become anxious, but to proactively adapt to the new regulations and comply with the new requirements. Specifically, keep your personal information updated promptly and do not fail to report address changes. Organize and securely store all immigration-related documents for easy future reference and submission. Diligently fulfill each new obligation, such as timely identity verification and annual reporting. Proactively monitor subsequent immigration policy updates to stay informed about relevant changes. This approach will minimize status risks and help you maintain your green card securely. Having covered the core changes, common misconceptions, and official responses to the new immigration law, we will now move on to the most practical, actionable steps. Based on the provisions of this new law, I have compiled a detailed, step-by-step action guide. You can start following it immediately to prepare in advance. Minimize status risks and ensure the stability of your green card status. The first step is the most critical and fundamental. Always obtain immigration policy information through official channels. Never rely on unverified information from unofficial sources. Firstly, Bookmark the official USCIS.gov website. This is the primary channel for all U.S. immigration policies and official notices. Specific provisions, implementation details, and operational guidelines regarding the new immigration law will be published here first. Log in regularly to stay updated on the latest developments. For broader U.S. immigration policy announcements, such as those issued by the Department of Homeland Security, DHS, monitor the official DHS website. To obtain the most accurate entry requirements and precautions for international travel and entry into the United States, prioritize the official website of the U.S. Department of State. I must reiterate, never rely solely on unofficial channels, such as social forums, WeChat groups, or social media feeds. Information from these sources is often unverified and prone to misinformation. Immigration matters tolerate no errors. Acting on incorrect information could lead to severe consequences and potentially jeopardize your green card status. Exercise extreme caution. If you haven't already, subscribe to USCIS email notifications. USCIS will notify you promptly via email about any major policy changes, the official launch of identity verification systems, the start of annual reporting periods, and other critical milestones, ensuring that you don't miss any important updates. Step 2. Carefully verify your personal identity information and relevant historical records, promptly correcting errors and supplementing omissions. First, locate your green card and meticulously verify all the details listed on it, including your name, date of birth, nationality, and green card expiry date, to ensure they are accurate and complete. Simultaneously, confirm that the residential address registered with USCIS matches your current address. If you have moved but failed to update your address with the immigration authorities, you must log in to the USCIS system immediately, or submit an address update request through official channels. Your address is the primary way USCIS contacts you. An incorrect or outdated address may prevent you from receiving important documents such as identity verification notices or annual filing reminders, which could affect your ability to fulfill your obligations and expose you to risks. Additionally, bear in mind that U.S. green cards are usually valid for 10 years. Take this opportunity to verify your card's expiry date. If it expires within the next year, begin preparing your renewal materials promptly to avoid your green card expiring. We also recommend that you start organizing all your international travel records now. Review your passport and document each entry/exit date to the U.S., the total number of days spent abroad, and the purpose of travel, for example, tourism, work, or visiting relatives. Simultaneously, compile all travel-related documents, such as flight itineraries, hotel reservations, and work assignment letters. These records and documents are crucial evidence during subsequent entry inspections and naturalization application reviews, as they demonstrate that you have not abandoned your permanent residency rights in the United States. It is essential to keep them securely stored. Step 3. Begin systematically compiling and organizing all documents proving your connection to the United States for advance filing. From this point onwards, consciously gather and organize all materials demonstrating your strong ties to the United States. These documents form the core evidence for identity verification, immigration inspections, and naturalization applications. They fall into the following categories. Firstly, proof of residence, such as long-term U.S. lease agreements, property ownership certificates, or utility payment records, which demonstrate fixed residence in the U.S. Secondly, financial evidence. This includes bank statements showing U.S. accounts, annual tax returns, and credit card statements, which demonstrate stable financial activity in the U.S. Thirdly, there are identity documents, U.S. driver's license, state-issued ID, etc., proving lawful status in the U.S. The fourth category is employment verification. such as an employment contract with a U.S. company, proof of employment or payslips, demonstrating stable employment in the U.S. If you obtained your green card through employer sponsorship, you must also provide the following materials: a current employment verification letter from your employer, payslips from the last few months, and W-2 forms to prove that you are still legally employed by the sponsoring employer. If you are planning to stay abroad for an extended period, you should prepare the following in advance: a letter of assignment from your employer for business travel, proof of U.S. property ownership or rental agreements, documentation showing that family members are studying or residing in the U.S. These documents will demonstrate your clear intent to return to the U.S. for residence. It is recommended that you maintain both electronic and physical copies of these documents. Electronic copies can be backed up on computers, USB drives, or similar devices. Physical documents should be organized in dedicated folders, with clear labels for easy retrieval and submission to prevent loss or omission. Step 4. Monitor official identity verification notices closely and complete verification on time to avoid missing deadlines. According to the U.S. Department of Homeland Security, biannual identity verification notices will be sent to all green card holders within the next 6 months. Stay vigilant and prepare accordingly. Firstly, ensure that the mailing address and email address registered with USCIS are accurate, as these are essential for receiving official notifications. Secondly, get into the habit of regularly checking both your physical mail and email inbox, as well as your spam folder, to prevent official notices from being mistakenly flagged as junk mail. Finally, once you receive an identity verification notice, complete the online verification process within the specified time frame. Failure to do so within 60 days will trigger an identity review process, leading to significant complications. Here's an additional practical tip. From the day you receive your green card, set a calendar reminder every 24 months on your phone or computer to prompt you to complete the identity verification process in a timely manner. This will help to prevent missed deadlines due to forgetfulness and reduce unnecessary risks. Step 5. Understand your specific circumstances and recognize when professional immigration legal guidance is necessary to avoid acting blindly. While I will explain the core points of the new immigration law, everyone's circumstances are different. Some reside overseas, some are investor visa holders, some have extensive travel records, and some are preparing for naturalization. Different situations require different compliance measures and solutions. Improper handling could lead to risks. Therefore, it is crucial to understand that you should promptly consult a professional immigration lawyer for personalized guidance when any of the following situations arise. Firstly, if you are planning frequent international travel involving multiple departures and extended stays abroad. Secondly, if you are planning to be outside Canada for over 180 days and are uncertain about the required documentation or how to fulfill your reporting obligations. Thirdly, if you are applying for naturalization and are uncertain whether your residency or travel history meets the new review requirements. If you have a history of immigration-related violations and are concerned about the potential impact on your current green card status or naturalization application, you should also seek professional immigration counsel. If you belong to a group that is required to fulfill annual reporting obligations, but are unclear about the process, content, or deadlines, you should also seek professional advice. I must emphasize that this video serves solely as an educational reference and for the sharing of information. It cannot replace professional immigration legal advice. Immigration laws are highly complex, and each individual's circumstances are unique. A professional immigration attorney can analyze your situation, assess risks, develop strategies tailored to you, and help you comply with the new regulations to maintain your green card status securely. Step 6. Prepare all the documentation you need for international travel in advance to ensure you can enter the United States smoothly. If you are planning to travel abroad for an extended period of more than 180 days, thorough preparation is essential to avoid any complications upon entry. Specifically, compile all documents demonstrating your strong ties to the U.S. into a dedicated folder to present to customs officials. These include the aforementioned proof of residence, employment verification, tax records, and documentation proving your family relationships. If you are planning to be away for more than 180 days, you must complete and submit Form I-131 Application for Travel Document to USCIS to fulfill your notification obligation. You should also prepare materials demonstrating a definite plan to return to the U.S., such as return flight reservations, employment verification, or U.S. rental agreements, property ownership documents. These materials prove to customs that your departure is temporary and does not constitute abandonment of your permanent residency status. When entering the U.S., allow extra time for customs processing, especially during the initial implementation of the new immigration law, as enhanced reviews may take longer. Plan your itinerary accordingly to avoid delays to subsequent arrangements and unnecessary complications. Having covered the practical guidelines, let's clarify the consequences of non-compliance. This is not intended to cause anxiety, but to emphasize the importance of these new regulations and help you avoid pitfalls through oversight. If you miss an identity verification deadline, USCIS will send multiple reminders offering opportunities to complete it, and your status will not be immediately revoked. However, completely ignoring notifications and refusing to fulfill your obligations will trigger an identity review, which could lead to interviews or even court appearances. Please note that long-term failure to fulfill obligations, such as identity verification and annual reporting, may be deemed non-compliance. In severe cases, this could lead to green card revocation. Secondly, if you return to the U.S. after an extended trip without the required supporting documents and have been outside the country for more than 180 days, you will face rigorous secondary inspection by customs. They will review your circumstances thoroughly to determine whether you have abandoned your U.S. permanent residency. In extreme cases, if they determine that you cannot provide sufficient evidence to prove that you have not abandoned your permanent residency, they may require you to sign Form I-407. This form essentially declares your voluntary renunciation of U.S. permanent residency. Once signed, your green card will be invalidated immediately, and you will permanently lose all the rights and privileges of a U.S. permanent resident, including the ability to enter and exit the United States freely. I must strongly emphasize here that when faced with a request to sign Form I-407, you have the legal right to refuse. However, doing so will result in your case being transferred directly to an immigration judge, who will determine whether you have abandoned your U.S. permanent residency. Subsequently, your case will enter immigration court proceedings. This process is extremely lengthy and complex, consuming significant time and money. Everyone should therefore strive to avoid this situation at all costs. I must reiterate a crucial point. U.S. immigration law has always explicitly required green card holders to maintain the United States as their principal place of residence. This is one of the core obligations of green card holders. Previously, enforcement was relatively lenient, leading many to overlook this requirement. The implementation of this new immigration law merely systematizes, standardizes, and tightens the enforcement of this existing obligation. It does not create a new one. If you are required to fulfill annual reporting obligations, but fail to submit the annual report, or if the submitted report does not meet the requirements, you may face consequences. At the MIDAS level, USCIS may request additional information or require you to resubmit the report. At a more severe level, your naturalization application process may be suspended or delayed. In serious cases, your naturalization application may be denied outright. Those who obtain their green card through investment immigration may face severe consequences, such as green card revocation and legal liability if USCIS discovers fraudulent activities, such as false declarations, abuse of immigration benefits, or failure to carry out the promised investment or business activities as stated in the application. Beyond these consequences, more serious violations include the following, which require particular vigilance. Firstly, if serious immigration fraud is involved, such as obtaining green card status through false documentation, fraudulent marriages or fake employment, or intentionally forging or altering supporting documents, USCIS may initiate removal proceedings. Once adjudicated for removal, the individual will be forcibly deported to their country of origin. Furthermore, they will be permanently barred from applying for any future U.S. immigration benefits or visas, and they will be barred from ever entering the United States again. Secondly, in extreme cases, serious immigration fraud may constitute a criminal offense, which is subject to criminal penalties under U.S. law, including fines and imprisonment. Thirdly, if your green card status is under review by USCIS, or if you have unresolved compliance issues, you may encounter difficulties when re-entering the U.S. after traveling internationally. Customs officials have the authority to deny entry and may detain you at the port of entry until your status is reviewed or the compliance issues are resolved. Fourthly, violations may also trigger a series of administrative consequences. These include inability to pass U.S. employment eligibility verification, which could lead to job loss, failure to renew your green card as normal, which could result in its expiry and invalidation, denial of applications for U.S. professional licenses. For example, for doctors, lawyers, and engineers, as these usually require verification of immigration compliance, ineligibility for U.S. social welfare benefits, including healthcare and retirement benefits, which are only available to compliant permanent residents. However, remember that these severe consequences only apply to those who disregard or intentionally violate regulations or act recklessly. Those genuinely committed to compliance have nothing to fear. You can avoid these complications by staying informed about new regulations, fulfilling your obligations on time, promptly correcting accidental errors, and seeking professional assistance when needed. USCIS has repeatedly emphasized that the purpose of these new rules is to standardize management, not to set traps. They will provide assistance and support to those who actively cooperate. To truly grasp the context and core significance of this new immigration law, and to adapt to these regulations more effectively, it is essential to view them within the broader landscape of U.S. immigration policy. While the two major U.S. political parties have held significant differences on many issues in recent years, they have demonstrated a high level of attention and consensus on the topic of immigration system modernization. This immigration system modernization encompasses three core areas. Firstly, the gradual transition of traditional paper-based immigration management processes to digital, information-based workflows, enhancing efficiency and accuracy while reducing human error. Secondly, it involves implementing more robust and stringent identity verification and oversight systems to combat immigration fraud more effectively, standardize application procedures, and ensure fairness and impartiality in immigration policies. Thirdly, it involves strengthening comprehensive oversight of immigrant status in order to resolve long-standing issues, such as backlogs and inefficient processing, thereby making immigration management more standardized and orderly. This new immigration law is a crucial component of the US's efforts to modernize its immigration system, and is a key measure to achieve these three core objectives. The current U.S. administration has made so-called status integrity a core priority in immigration policy. The fundamental principle is clear and straightforward. Any individual granted U.S. immigration status must fulfill the statutory definition of that status and the corresponding legal obligations. They must also refrain from abusing immigration benefits and must not obtain status through fraudulent means. Specifically, permanent residents must physically reside in the United States, fulfill all obligations of permanent residency, and maintain substantial ties to the country. Individuals entering on work visas must perform the occupation specified in their visa. They cannot change jobs without authorization, sever ties with their employer, or engage in activities inconsistent with visa requirements. This is not an empty slogan from the U.S. government, nor is it an arbitrary requirement. It is backed by concrete data and aims to address long-standing issues in USM's immigration management. Data released by the U.S. Department of Homeland Security in 2025 indicates that 12 to 15% of U.S. green card holders cannot be located at their registered residential addresses when the government sends relevant notifications, such as green card renewal reminders or policy update notices. These individuals either failed to update their addresses after moving or have been living abroad long-term, essentially relinquishing their U.S. permanent residency rights while still holding green cards. This poses significant challenges for U.S. immigration management. Furthermore, numerous documented cases reveal that some green card holders primarily reside outside the U.S. for extended periods, some never returning yet retain their green cards for years. This abuse of permanent resident benefits contradicts the original intent of U.S. immigration policy, which is a key reason why the government is introducing new immigration legislation. In fact, a review of the history of U.S. immigration policy reveals that this is neither the first tightening of green card regulations nor the first major overhaul of immigration policies. Examining the evolution of U.S. immigration policy shows that similar changes have occurred multiple times in the past. For example, following the 9/11 attacks, the U.S. government introduced a series of immigration policy adjustments for national security reasons. These included numerous document review and identity verification requirements, as well as significantly strengthening oversight of immigrants. Similarly, Congress passed the Immigration Reform and Control Act in 1996, which implemented stringent immigration policy adjustments and intensified crackdowns on illegal immigrants while strengthening management requirements for legal immigrants. As early as the 1950s, the U.S. first established an immigration registration and reporting system requiring all immigrants to register on time and fulfill reporting obligations. These historical transformations reveal a clear trend. Each generation of U.S. immigration law updates adds responsibilities for immigration holders and refines identity verification and oversight mechanisms, making immigration management increasingly stringent and standardized. Many may wonder, why did the U.S. government choose the period from late 2025 to early 2026 to introduce such a stringent new immigration law? This timing is not coincidental, but rather the result of three key factors converging. First, significant technological breakthroughs have finally provided the robust technical support necessary for implementing the new immigration law. After years of system modernization, USCIS has successfully established a large-scale digital identity verification infrastructure. This enables the efficient and precise verification and management of identity, residency, and exit records for millions of green card holders, a crucial prerequisite for the smooth implementation of the new immigration law. Secondly, a rare bipartisan consensus has emerged, providing political safeguards for the law's enactment and enforcement. Although the two major parties in the United States often engage in political maneuvering and hold significant differences on many immigration policy issues, they reached a consensus on the need for improved tracking mechanisms within the immigration system, strengthened identity oversight, and combating immigration fraud. This consensus enabled the new immigration law to pass through Congress smoothly and take effect rapidly. Thirdly, the immense pressure caused by the backlog of naturalization applications led to the introduction of the new immigration law. In recent years, a growing number of green card holders have submitted naturalization applications, resulting in a substantial backlog of cases. This has significantly increased the review burden on USCIS and severely impacted processing efficiency. In order to alleviate this pressure, improve processing efficiency, and ensure the authenticity and compliance of naturalization applications, USCIS urgently required more efficient and rigorous review tools and management mechanisms. This new immigration law precisely addresses this need by enabling USCIS to swiftly and accurately verify applicants' continuous residence and compliance status, reduce fraudulent applications, and ease the backlog. Several statistical data points and development trends help to clarify the reasons behind the introduction of this new immigration law by the U.S. government. According to data released by the U.S. Department of Homeland Security and USCIS, the United States is projected to have 133 million green card holders by 2025, a figure which continues to increase annually. Over the past 3 years, naturalization applications have surged by 23%, reaching an all-time high. With this substantial increase in applications, the projected processing time for naturalization has increased significantly from 8 months to 14 to 16 months, with some applicants facing even longer waits for final adjudication. Concurrently, the number of immigration fraud investigations involving permanent residents has risen annually by 500% since RD/, including cases such as sham marriages, employer sponsorship fraud, and investment immigration program violations. These figures collectively highlight the pressures on the management of the U.S. immigration system and explain why the government is urgently implementing stricter identity verification and oversight measures to regulate immigration, maintain order, and combat fraud. Finally, a heartfelt message to all green card holders. The new 2026 immigration law is not primarily about tightening, but rather about standardizing. It does not strip you of your core rights, but rather sets out clearer, more specific requirements for maintaining stable green card status. The days of resting easy after obtaining a green card are over. Now more than ever, you must take responsibility proactively. Complete status verification on time. Retain relevant documents properly. Regulate your outbound travel behavior, and stay informed about official policy updates. Provided you remain lawful and compliant, maintain genuine ties to the U.S. through residence and employment, and actively cooperate with USCIS verification efforts. HUE will safeguard your green card status and advance plans such as naturalization smoothly. We also encourage you to share this practical guide with green card holding friends and family nearby. Together, we can avoid pitfalls, stay compliant, and protect the fruits of our hard-earned immigration journey.